name is Seth Horvath, and today's topic is a big one. We're all very enthusiastic to talk about it, so let's get right to it. There is a pretty well-known book. It's called The Curmudgeon's Guide to Practicing Law, and it humorously describes depositions. It says if you're defending a deposition, it's 7 hours locked in a room with a compulsive talker, that is the witness, and a sociopath, the taking attorney. And it says if you're taking a deposition, it's 7 hours of pretending to be a sociopath while locked in a room with an amnesiac, the witness, and a compulsive obstructionist, the defending attorney. And there are two sides to every story. We're going to discuss both today in Taking and Defending Depositions, episode 1 of the Financial Poise series, Doing Depositions. You can read more about financial poise in slide 2 of the slide deck. And I want to quickly introduce our panelists for the day, or better yet, I'll have them introduce themselves just by stating their name and their law firm. Frank, you can go first.
I'm Frank Delusky with Phillips Lytle in Chicago.
And Warren will take you second.
Warren Holland with Goldberg, Miller, and Rubin in New York and Philadelphia.
And Max, you next.
Max Stein here with Maxon, Mago, and McCauley here in Chicago as well.
Thank you very much. And as I mentioned, my name is Seth Horvath. I'm with the law firm Nixon Peabody LLP in Chicago. You can see our names on slide 5 of the slide presentation. You can read our bios if you so choose on slides 18 through 21. And about those slides, I'm going to try to call your attention to slides that are relevant to whatever we're talking about so that you can take notes if you want to take notes. Don't worry, though, if you're listening as opposed to watching this webinar, you're going to be fine because the slides are not critical. They're just there for guidance. Thank you to our co-producer. That's the National Law Review. You can read more about the National Law Review on slide number 3 of the slide deck. The last thing before we start, the last housekeeping matter, slide 4 has a disclaimer on it. You are not our clients. We are not your lawyers. What we do here today is for your general education and not for you to act on without appropriate legal advice. And we appreciate your taking that to heart. But without further ado, we'll get right into it and start our topic for the day. And in order to do that, I want to put the importance of depositions into context for you, our audience members. And in order to achieve that, I'm going to ask each of our panelists here an initial question, drawing on their experience with depositions. I'm going to turn first to Frank. Frank, I wanted to ask you first to lead things off. Have you ever been involved in a case where a deposition had important implications for the outcome? And if the answer to that is yes, and you could elaborate for us for a moment, we're certainly interested to hear.
Yeah, thank you. I think, particularly if you practice in commercial litigation, which I do, depositions are going to become important in almost any case that you have, whether that's pretrial, which is before you get to court in front of a jury or the judge. Your depositions are the only testimony that you have, and so it can be important as part of negotiating settlement or filing for summary judgment or a multitude of things, seeking additional discovery, things like that. And then when you get to trial, obviously you oftentimes will have the witness testifying live, and sometimes depositions don't. The importance of a deposition might not become as apparent until the witness starts testifying. For example, we had a case once where there was a dispute over whether or not the contract was too vague to be enforceable. And a witness got on the stand and for about 45 minutes described all of the various conversations he supposedly had with the counterparty, describing the various terms of the contract and how it would work. And after 45 minutes of that testimony, it was all blown up with one simple impeachment, playing a question he was asked at his deposition, which was, prior to signing this agreement, did you discuss its terms with anyone from the other side? No. and that was that his entire testimony imploded after that.
It's a cautionary tale, I suppose, and one we appreciate your sharing with us. Warren, I'll turn it to you with the same question. Have you ever been involved in a case where a deposition had important implications for the outcome? And if so, could you share some of that for our audience here today?
Well, yeah, of course. I'm primarily a trial attorney, and ideally, every deposition I'm involved in has some sort of implication for the case. And maybe an easier question is, are there depositions that don't have an important implication? Because, those are fewer and further between. So I can think of one example, though. Like sometimes you're defending a case where you're one of many parties, and maybe your party's not implicated, but there's still good reason to pay attention. I have a lot of cases like that in New York in particular. And there are ways to ask just one or two questions that will set up your case for summary judgment. So it's very important to pay attention and take it seriously. Yeah, I think learning how to approach a deposition and effectively do it, and having that broad view of why you're doing it is extremely important, which is why we're here today.
Points well taken, and appreciate that insight. Max, I'll turn it over to you with the same question. I'm hoping you can share with us any instances where you've been involved in a case where a deposition had important implications for the litigation.
Sure. And building on something that Warren just said, every deposition should be important, even the one where you learn nothing, because hopefully by learning nothing, you've eliminated that witness and sort of taken them off the table moving forward. And you've done it in a way that closes the door, puts that witness's knowledge or lack thereof in a box. You put the box on the shelf and you move on. I've been involved in plenty of litigations where deposition testimony played a big role. I actually can't remember specific instances of the depositions playing the big role along the lines of what Frank is talking about. What I really can actually remember are those cases where we had deposition transcripts that weren't quite as good as I wanted them to be, and how hard it can be, particularly to write a cross-examination when your deposition transcript isn't quite as buttoned down tight as you want it to be. And that underscores the importance of the deposition itself, because when you get to trial, particularly if you're going to be cross-examining a witness, what you want is a clear deposition transcript that you can just walk through, get all of the testimony you need out of that transcript, put it into easy bite-sized pieces of cross-examination where you're doing the testimony more than the witness is doing the testifying, and you can use that to present your case. And when you don't have that, and when you get to the point where you're writing that cross-examination and you realize, oh, this answer was never quite buttoned up, oh, this one isn't quite what I thought it was or what they told me it was, that can be really annoying and potentially problematic for the case of trial.
So I think we have a great point of departure here. I think we have a consensus that depositions are important. I like Max's statement of the thesis that every deposition ought to be important. And with that, I'm going to turn to Frank with another question in terms of preparing for a deposition. Frank, as an attorney taking a deposition, what are your main objectives when you go into a deposition?
I'll give a very lawyerly answer, which is that depends, because depositions are really not monolithic. Sometimes, kind of to the point I think Max made earlier, sometimes you're doing it because you don't really think this witness has much to offer, but you need to cross that box and neutralize them for trial. And as a young associate, I remember spending many weeks on the Gulf Coast taking what we called closeout depositions, which your whole objective was to walk in there, establish on the record that this witness has absolutely nothing useful to say at trial, and move on so that you never have to think about them again. So there's one end of the spectrum like that. There's the other end of the spectrum where you know that this person is going to be, the absolute key witness for your adversary. So you need to treat it, you know, you need to treat it as if it's their cross-examination, because you are setting them up for an ultimate showdown in front of a jury or a judge or an arbitrator, whatever it may be. And then there's everything in between, gathering information, trying to identify new sources of discovery that you haven't yet explored. Obviously, locking in admissions that you'll use you'll get feed to your experts, who will then rely on them in their expert reports, and then assessing the credibility of the witness for trial. But that all is to say, like I said at the beginning, it depends, because there's a million different uses, and it really depends on how they fit in the case, and what you need to establish, what you need to use them to establish.
So I think it's fair to say that when we're doing a deposition, we're not just going in and asking random questions. There's a methodology to it. Is that a fair kind of summary of what you're getting at, Frank?
Yeah, I think that's pretty accurate.
And I would just add to what Frank was saying that all of those possible reasons for or approaches to the deposition are certainly valid. And if you're taking a deposition, you should be, even if you are going in with one purpose, you should be prepared to realize in that room at that moment, oh, wait, we need to do a different deposition than I expected I was going to be doing. So let me switch gears now and start doing a very different deposition. I remember one securities fraud case I had where I was deposing a person who had been an accounting auditor, and she was no longer working professionally as an auditor. And so she had apparently chosen an approach that she was just not going to remember anything. She was the amnesiac from your example at the beginning, Seth. And I went in with all of these documents ready to ask her all kinds of questions about all of these memos she had written. And her approach was she was going to remember nothing. So I, on the fly, switched my approach and would ask the same 5 questions about every document to make sure she could not come back later and tell us anything that wasn't already in the document. And we did that for 2 days, and everybody had the most boring experience possible. And then we moved on. It was a very different deposition than we thought going in, but it was nonetheless effective at the end.
And the flip side of that is also true. You may go into a deposition expecting it to be a closeout. I'm going to be in and out. I'm going to make my flight home. And then all of a sudden the person starts rambling, and you realize this isn't in my outline because I didn't expect this person to know anything, and you have to pivot and just act on the fly.
And rebook that flight fast.
Perhaps the most important part. I'm gonna backtrack one step to sort of the planning phase of depositions. I'm going to turn this question over to Warren, and I wanted to ask Warren, to what extent do the rules of the jurisdiction in which your deposition is proceeding factor into your preparation?
Well, it's not the main factor that I prepare for, but it is important to know. So I personally practice in 3 different states, primarily New York, Philadelphia, or Pennsylvania, and New Jersey. And in each place that I practice has got different rules, and not only that, there's a different culture with how attorneys are taught to approach depositions, and that's important to know too, because the way a deposition will proceed in Manhattan is completely different than the way it will proceed in upstate New York and then in Philadelphia. And there are rules that change. For example, one of the usual questions you'll get before a deposition in Philadelphia is by the court reporter, and she'll say, or he'll say, does everyone agree to the usual stipulations? They don't explain what that is. You don't learn that in law school. It's not written down many places that I know of, but it is important to know because you're waiving quite a few things if you agree to it. And the practice is to agree to that, but you should know what you're agreeing to before you do that. In New York, the way depositions proceed is by order. It's an order that's issued at the beginning of every case, and plaintiff always goes first on a different day, and then the defendants go in sequence on separate days. In Philadelphia, that's not the case. There's a lot of gamesmanship on who goes first. Is it the defendant, or is it the plaintiff? There's a lot of people that have illnesses suddenly the day of. And these things they're important to know because, you know, when you're preparing and you have your objectives in mind, you want to at least be prepared to encounter these issues. And then on top of that, there's other technical issues like time limits. You know, in federal court, there's very specific time limits. Other places there are not. Hopefully, I hope for everyone listening that you don't get into a situation where you're worried about time limits, but it does happen. You can have somebody stretch a seemingly simple deposition beyond bounds of reason, and you may have to reach out to the court, or you may have to decide when to stop the deposition if you're defending it. So these things are important, but again, I think that the overall objectives, as Max and Frank have been discussing, are things to keep in mind, and then have a working knowledge of the rules and the jurisdiction that you're in, so that if you do have a conflict, you know how to handle it.
I want to focus the group on another aspect of planning, since that's kind of what we're touching on here. And Max, I'm going to direct this question to you. Do you follow any guidelines in deciding which witness or witnesses you're going to depose? I think you may have touched on this a bit in one of your earlier remarks, but that's the question. Curious to hear your thoughts.
Sure. So I don't necessarily have guidelines. You know, I usually begin with the witnesses that the parties have identified as people who may have knowledge. That's either going to be in initial disclosures or in interrogatory responses. And usually you're going to see a few of the same names over and over, and those are probably the people who actually have some of the knowledge that you're going to want to get. Beyond that, you may want, as we've been talking about, to depose some people to confirm that they don't know anything. One of the more critical pieces to think about is to think about people who might be a little bit friendly to your side, and whether you want to get their testimony down on the record in a deposition, or whether you want to hold that back and wait and do that, have them provide the testimony you want from them at trial, banking on the assumption that they'll continue to be friendly to your side throughout the life of a litigation, which, as we all know, can take quite a while, and B, that they'll still be willing to testify even if you can't compel them to testify. So those are some of the things that you definitely want to think about as you're going through that list of potential witnesses. And again, this is very much art, not science. So you're going to want to try to figure out which witnesses you really think you need. Candidly, if you are dealing with, let's say, a retired person who's no longer going to be under much control, that's probably somebody you would want to depose, even if under other circumstances you might think you don't need to depose them, both because you might not be able to control them, and you want to be sure that you have their testimony recorded should they die or anything else happen that prevents them from testifying. So you definitely want to figure these things out. You want to make sure that you have all of the pieces that you're going to need to present at trial in some form that you can control. And so if you know, well, I've got the CEO who can testify to this, and he's or she's always going to be available, I don't need to depose that person. But if you've got the salesperson who tends to change jobs every 2 years and is unlikely to be anywhere near the jurisdiction by the time we get to trial, that's probably somebody you want to be sure you depose, even if you might otherwise think, I don't need that person's deposition.
I think, and I hope our audience is sensing one theme that's emerging here, is deposition is a very thoughtful exercise. It's not just about showing up in the room and asking the questions. There's a lot that goes into it in terms of planning. There's a lot that goes into it in terms of forethought and fitting into your case as a whole. And we have kind of a big picture now of some of those elements that go into planning. So I want to get a little more granular on the planning. And I'm going to turn this question over to Frank. And the question is as follows for you, Frank. When you're structuring an examination for a deposition, what are some ways that you use for determining the organization of your examination?
Similar to my last answer, it always depends on what the goal is and how the witness fits into the story. But also going back to, well, what are your goals? Are you trying to discover new information, or are you trying to lock down admissions, or is it a little bit of a hybrid? Sometimes a chronological path forward makes most sense because it tells the story. If, for example, maybe you're dealing with a fraud case and the timing is really important. What did you know and when did you know it? You might choose to follow a chronological kind of organization. But you may be deposing an expert who has 6 different opinions and they don't overlap, and obviously that's going to lend itself more to separating your deposition questioning by subject matter. But those are all. It all depends on the witness and how they fit into the case, and also the case itself, I think.
And I suppose there's always a situation where you just need to keep a witness on their toes and there really is no pattern. You're just kind of seeing how they respond to things and testing them. I mean, is that a kind of a fair characterization of at least some instances?
Yeah, and I think that some people, when they're preparing their deposition outline or material, some people deliberately will jump around from subject A to subject B, back to subject A, now to subject C, because it gives the witness, especially if you have a witness that you think is pretty hostile or maybe willing to lie. It's harder to keep up the facts of a lie if you're constantly moving from them between subject matters. And unless you are playing the deposition at trial, the organization really often doesn't matter. If you're citing into a brief, it doesn't matter if you're citing something on page 74 and then going to cite something that originally was on page 5.
Yeah, that is a good point in terms of, you want to get the information you need. Sometimes the order doesn't really make a difference. So I want to stay on this topic of sort of preparing for depositions and what you can do to prepare well. And I want to talk a bit about document use at depositions, and so often documents are an integral part of a deposition. And I'm going to turn this question over to Warren. Warren, I'm curious to know what considerations factor into whether and to what extent you're going to use documents during a deposition and make it sort of paper heavy versus paper light.
Yeah, it's a great question. And I think it really depends on the nature of the case that you're dealing with and your objectives. There a lot of personally, I avoid it in a lot of injury cases that I handle. I like to just talk and have a conversation, along with what Frank was saying. Like sometimes you jump around, and there's a real art in that. But there are plenty of cases where the documents are the central issue in the case, and I could think of 3 reasons why I would use documents. One would be simply to explore them. If I in the med mal context, a lot of times you have charts that are you can't read 2 words, and you need the witness to explain to you what's on the paper. And along those lines, another good reason to use documents is to authenticate them. And it's particularly records in contracts in that context that you need to either support or your case or your defense, and you just need them to be authenticated for the purposes of summary judgment or trial. You just kind of along the lines of the lock-in deposition, you need to establish that this is the real document and that there's no dispute over it. And finally, the thing that I kind of avoid is confronting witnesses with impeaching documents, and that's in cases that I have an eye towards trial. I know that I'm going to be there. I'm going to have the witness on the stand at some point, and it's a record that I just don't want to use and lose the effect of during the deposition. And again, people might have disagreements with me here, but I see that as being a big mistake a lot of times. And I've been part of depositions where people have used documents in that way to cross-examine. And then I've been at trial later on where the entire effect of that is gone. Now, there are reasons to do it. I had a deposition just yesterday where I did exactly what I'm saying I don't like to do. And I was doing it because the case, I deal a lot in fraud cases, and it was a case where I think that the attorney who was representing the witness I was deposing, was teetering on the edge of whether he was going to drop the case or withdraw his counsel, and I wanted to push him, and I took a lot of time going over documents with the witness. It went as I predicted, and now the attorney is withdrawing, and likely the case is going to go away. But I went into that knowing that whatever effect I was going to have was going to be used in the deposition and not at trial, and I run the risk of them regrouping and coming up with some, way to explain the documents that I used, although frankly, it's kind of impossible at this point. But, you have to think about that. Otherwise, if you don't need it, if it's not advancing one of your objectives, you can always keep those documents. It does slow a deposition down. It does sometimes, have a detrimental effect as opposed to a positive one.
And I think that's a nice sort of segue into our next overall topic about what's happening during the actual taking of the deposition. Warren started to touch on that a bit in terms of things that are going on in the room, so to speak. And I'll advance that topic, and I'm gonna turn it over to Max. And Max, the question for you is, what guidelines do you follow in terms of when to lead a deponent versus when to ask open-ended questions during a deposition? Can you shed some light on that and your approach?
Sure. So in general, and again, the overarching answer of it depends is looming here. But in general, what I would say is I try to ask the overarching open-ended kinds of questions, because what I view a deposition as most useful for me is to get the witness's version of the story. And so I want to be sure I have gotten from the witness their version of the story. One of the things that I often talk about, particularly when preparing witnesses for their depositions, is the fact that we, the lawyers, get to relive a part of somebody's life. And we are looking at it with 2020 hindsight, and we put together what we think happened. And oftentimes we screw one little thing up. And it means that we've put together a tale that goes like this, but we messed up this point. And in fact, it should have gone like this. And so what I want to do is be sure I'm asking open-ended enough questions that the witness has the opportunity to help me better understand what happened. One of the things that I will sometimes or frequently do is ask the open-ended questions and then follow it up with much more leading questions along the lines of, I want to make sure I understood what you just said. As I understood it, what you said was, you came to the intersection, is that right? You saw the traffic light, is that right? You saw the traffic light was red, is that right? You came to a complete stop, is that right? And I do all of that only after having them tell me what they had happened. And that way I sort of get to have my cake and eat it too. One of the lawyers who trained me called that making pages, where you're putting together pretty clear, direct testimony that's going to be easily cited in your motion for summary judgment. But you only do that after you've gotten the broad questions out of the way and learned the information that you can get from that witness while you have that witness available to you to tell you what they know.
Yeah, I appreciate that description of sort of framing it the proper way and having your cake and eating it too, if you will, if you do it properly.
There is one more thing that I do want to emphasize, which is I am a big proponent in shorter, simpler questions, especially at a deposition, and especially if what you're trying to do is learn what happened. Oftentimes, we lawyers will present 5 predicates to a question. And I'm sitting there the whole time, like, just ask the question, just ask the question, just ask the question. And so oftentimes the best question is, what happened next? Or why? Or can you explain that? Those kinds of very basic questions, which are kind of standard conversational questions, are oftentimes far more effective than the most cleverly written lawyerly question you can possibly put together.
And I would add, can sometimes really lead to a transcript that's far more useful when you have these nice short questions and nice short answers.
Yep.
So we're in the deposition now. We're kind of engaging with the witness. That's the point that we're discussing and the point we've gotten to in our panel. I'm going to turn the next question over to Frank. And Frank, I'm curious, how do you deal with a defending attorney during a deposition who's clearly trying to obstruct that witness's testimony, despite you doing your best to keep the witness on track with documents like Warren was talking about, or asking short questions like Max was talking about? What are some of the things that you do to address that?
Yeah, I think maybe as a starting point, the broader question is what lands an attorney into the category of being an obstructionist, and typically we've all seen it, and it comes in different flavors, I would say, but usually they're talking too much. They're giving speaking objections. They're testifying that may be intended to coach the witness. It may be intended just to throw you off track and ruin your train of thought. Maybe just intended to run out the clock on you. But either way, usually they're just talking when they shouldn't be talking. And I think I kind of always think of these people as bullies, in the same way that everyone has a different way of dealing with the bully. It's very personal to every attorney's style. One of my very good friends, she was excellent handling these types of people, but she would do it very differently than I would. She would engage with them and just humiliate them and shame them into shutting up, essentially, and she was very effective with it. That's not my style. I tend to have a longer give them a little bit of a longer leash, and ignore it at the beginning, so I'm not jumping right out the gate and saying you're acting inappropriately. And then I like to put them on the spot, and I identify what exactly they're doing. A lot of times when you're taking a deposition, you'll have a real time, so you're getting a copy of the transcript as it's being prepared. It's the rough or whatever. And at some point I might just say, counsel, your last objection went on for a page and a half. That's clearly inappropriate. This is the second time you've done it. Could you please stop making speaking objections? And then they do it again, and I'll say the same thing. That now you just went a page and a quarter with the last speaking objection. This is the third time you've done it. Are you? And then I'll ask them, are you going to continue making speaking objections? And sometimes that's enough to stop them. Sometimes they won't until you threaten to call the judge. And I was taught as a very young attorney that, pick your battles carefully, but don't be afraid to call the judge if they really are acting inappropriately. Because I think judges generally, when we're in a deposition and we're not in front of the court, they expect us to be professional and they expect us to be self-policing. And when an attorney is taking advantage of that situation, judges can oftentimes come down pretty hard on them. So while I have threatened to call the judge before and had every intention of following through if necessary, I've been lucky that by the time we've gotten to that point, I've made my record. They know exactly what I'm going to say to the judge when I call the judge, and they know exactly the examples I'm going to have the court reporter read to the judge. And then that usually has been, in my experience, effective of getting them to just be quiet.
I would just add one thing, which is I find it's very important to note whether the obstructionist attorney is being effective or not. One of the things that I've observed is if I am doing my job and have developed an effective rapport with the witness will be as annoyed by their own attorney's speaking objections as I might be. And in that circumstance, I am perfectly content to let that obstructionist attorney keep objecting for as long as he wants. 1.5 pages, take 3.
Yeah.
While his witness is sitting there stewing, knowing that this is making the deposition go longer, and the witness just wants to tell me what the witness knows.
That's a great point, and I agree 100%. And in that, if it's not landing with the witness, I think you can really take it as an opportunity to make the witness hate their own lawyer, and you can just say, sir, I'm really trying to get you out of here for dinner with your wife. I'm really sorry that they're wasting our time. I'll ask the court reporter to repeat the question for you. And sometimes you can see them giving their lawyers the side eye, saying, "What the hell are you doing here?"
And now we'll flip the script a little bit and we'll talk about the witness that's being an obstructionist. And for that, I'm going to turn to Warren, and I'm going to ask you, Warren, how do you deal with an evasive witness or a combative witness?
Yeah, I think in a lot of ways that's an easier question than the one Frank had, because one of the objectives of a deposition, amongst many, is to get a sense of the witness and how he or she is going to be, and what would happen if you put them on the stand. And I think one of the things I tell my associates is that if you get into a situation where the witness is very combative, rude, doesn't answer the question, that it's actually a good sign. And I handle both defense and plaintiff's work, and it's a good sign on both sides. It can be frustrating, but the important thing is to remain patient, remain focused. If you have to repeat the question multiple times, that's what you have to do. Sometimes you move on to a different topic and come back and ask the same question. You just have to take that extra time to do what you can to get the information. Now, some witnesses will completely shut down and they won't answer questions. And that's when you likely have to get the court involved, not by calling the judge in the middle of the deposition, unless it's an extreme example or the attorney is the one being obstructive. But you may need to file a motion to say, I just couldn't get the witness to respond. It's exceedingly rare. I've only had it once or twice in my career. Most of the time, the witness will fall into two categories. There'll be the amnesiac, like we were talking about earlier. And I think it was Max who made the point earlier that if you get into a situation like that and you find somebody that's just not answering questions, or they're saying that they don't have any recollection, that you flip and you try to lock them in on the fact that they're just not going to answer the question. On the other end of the spectrum, you have somebody who'll just fight with you and argue and talk and talk and talk. And those witnesses, if you just let them, they will, in the midst of, you may have to pour through the transcript later on, but they'll say something that it will impact their case. And the important thing to do is keep your ears open and listen for it. And when you hear it, you take note of it. You may not immediately lock them in then, but at some point you should try to lock them in on that important thing that they said that hurts their case. But that's my general approach.
I'm going to stay with this line of thought of witnesses kind of saying things during the deposition that are new to the ears of the lawyer that's taking the deposition. And on that topic, I want to ask Max about something that I'm sure we've all seen at one time or another during a deposition. If a witness discloses the existence of new documentary evidence during a deposition, what do you think the best way is to proceed if you're getting that new information in real time during the deposition and you're trying to decide what to do with it?
So in general, I would say the best way to proceed is whatever is the path that you are most likely going down already. So you, in general, shouldn't let the witness's disclosure of something throw you for a complete loop. So most commonly, what I will say is, so if a witness identifies something that has not yet been produced, but says that they could produce it, I will note that and ask my opponent to produce that after the deposition. If the witness says, oh, I have it here, I will get a copy of it, but probably not use it at the deposition at that moment unless I really feel like I have to. And the reason is that's free information effectively. And one of the things that I often talk with my clients about is how we want to maximize our free information and minimize the information we quote unquote have to pay for. And so when a witness is going to say, oh, there's more, I'll get it to you. To me, that says I get another opportunity to ask that same witness more questions. And so I don't want to necessarily ask the witness the questions about that document at the deposition I'm already taking. I'd rather continue the deposition. I'd rather complete the deposition I was going to take, continue it, and then reconvene to ask about the new information and perhaps clean up anything I might not have quite exactly covered as well as I might have the first time around. And so use these opportunities as quote unquote free information or free opportunities, and do the return, reconvene, continue the deposition. The exception would be if it's a highly contentious litigation. You already know that you're going to be fought tooth and nail about bringing the witness back. You've got a sense the judge might not actually let you bring the witness back, and you need to ask them about that information. That's the circumstance where you're going to want to go ahead and ask them about it in that moment.
I appreciate all the thoughtfulness in that answer. Deposition's a fluid situation, as one of the things emerging from our discussion. A couple questions that I want to just get into real quickly about the format of a deposition in this day and age of virtual versus in person. And I'm going to turn this question to Frank. Frank, do you think there's any difference between the effectiveness of virtual depositions and in person? And if so, would you be able to touch on that for a few moments for us?
Sure. As someone who never really encountered a virtual deposition until COVID, I'm outside of my comfort zone. I feel like I have less control. I'd like to be able to hand the document or point to a paragraph in front of the witness. It's for me less comfortable, and you also have issues with, for example, a witness being in a room with more distractions than we might have in a conference room in a law firm. That doesn't mean that virtual depositions can't be effective. We just have to adapt to them. And I think that the reality is that they're probably going to become more common because the reality is that they're cheaper. If you have to take 12 depositions in 12 different states, that's a lot cheaper to do from your office than it is to take 12 plus flights and stay in hotels to do it. And I think at that point you just start to decide which is a deposition that it's important enough that I really want to do this one in person, and which are the ones that for the sake of saving cost and time, I can get by with a virtual.
I will jump in to say I see the value of virtual depositions in some instances, substantively as well as cost effectively. I have been in one of the things about a virtual deposition is the witness is directly in your line of sight, just as we all are right now. That witness has a camera pointed directly at their face that's much closer than you might be looking at their face. And so you're looking at their face much more closely than you might if you were in a conference room at a law firm. And I have taken depositions where I have watched a witness realize they just got caught in a lie. And I've watched it wash over their face because I was looking at a screen that had their face large on the screen because the camera was focused directly on their face. I literally saw it go across their face, saw them realize that they were caught in the lie and try to figure out how they were going to get out of it, not be able to get out of it, and then acknowledge the lie. And I don't think I would have noticed it go across their face quite the same way if I'd been in a conference room looking down at my outline or turning to get the next document ready or those kinds of things. I will also say I sometimes prefer presenting documents virtually as opposed to in person, because I can have more documents at my fingertips and use them more quickly without having had to make 10 copies and fumble around for it. So but by the same token, I have no idea what's going on in that room that person is in. And there may be other distractions, there may be other cues going on, those kinds of things. So there are definitely pluses and minuses of both.
And again, another theme I think is emerging from this is depositions are a constant weighing of pro and con, and adaptability. And I think that's a good point in terms of discussing virtual versus in person, to pivot more over to the defense side. And I want to start the questions on preparing to defend a deposition by asking Warren something about witness preparation. Properly preparing a witness for a deposition can be a significant time commitment on the witness's part under certain circumstances. How do you get buy-in or cooperation, Warren, from a witness who doesn't really want to make sufficient time to prepare?
Yeah, that's not easy. Honestly, I think the biggest or the best tool that I have is just trying to develop a rapport with the witness before you get to that point, so that they trust you, that they like talking to you, that they understand the process, what's happening to them, what needs to be done, and the plan. Because if you don't do that, it's just a time commitment for them. They just feel like it's an annoyance, like they don't understand why they have to do this. And I get that a lot of questions like, I don't understand. Like, don't you have the documents? Like, I don't understand. Like, why don't you know what happened? Isn't there a video of this? And just being able to explain to them what we're talking about right now, why this is important, what are the objectives, why the other side is entitled to do this, and talking them through that, talking them off the ledge is the best thing that you can do. And then once they understand, then you can take them through the steps of preparing. And different witnesses, it's more important in cases where you have, say, like a corporate designee. Hopefully, you're not in a situation where your corporate designee is giving you problems, but I have been there, and the more powerful they are, the more difficult it is to take them through that process. But you have to do it, and you have to invest the time, and maybe if you know that they're going to be difficult, start months in advance. Start, touching base with them, talking to them, preparing them for what's coming, what's going to happen, and why. And that's really the best way, I think, to do that.
And I think in your comment there, Warren, you used a word that has come up many times over the course of our discussion now, plan. I mean, it's good to have a plan, and a witness who knows you have a plan may be more receptive to helping you execute that plan. So just as on the taking side, on the defense side, it's good to be methodical, good to plan out your objectives and the like. Let me kind of pivot for a moment here, again, on the topic of preparing a witness to be deposed. And this question is going to be for you, Max. When you're preparing a witness for a deposition, what are some things you think you should be mindful of in communicating with that witness whom you're preparing?
So the first thing I do is I actually go through with the witness I'm going to be defending. I go through some basic rules, trying to make sure that they understand what the deposition is, what it's going to feel like, what it's going to look like. I go through some rules. The first 3 rules usually are to tell the truth. And one of the things that I'm trying to hammer home to my witnesses is the value of telling the truth, including the value of not having to remember 2 different versions of a story. The beauty of telling the truth is you only have to remember the one version. One of the reasons I do that is because much of what we discuss, even in preparing for the deposition, could potentially be discoverable if it doesn't involve the communication or the conveying of legal advice. And so if we're just talking about the facts of what happened, it is possible that a clever and persistent questioning attorney might get into the specifics of what we discuss. And that's something that everybody should be aware of. The other thing that I do make a point of getting into with my witnesses is the fact that a deposition is a weird thing for a whole lot of reasons. And as a result, it means that it's not a conversation. And one of the things I tell my witnesses is the normal rules of polite society don't apply. And so if it feels awkward, that's not our problem. That's the questioning attorney's problem if the questioning attorney cares. But it's perfectly appropriate and perfectly okay for a deposition to be the most awkward experience you will have in your entire lifetime. In fact, that probably means you're being a pretty effective witness. And then the other thing that you need to think about and decide about is how much you want to remind your witness of things that they might once have known but have now forgotten. And Warren was talking about corporate representatives. That's one category of people, and those people do need to know what they're being asked about. But a fact witness who might have looked at a contract 5 years ago and might not remember anything about it, you need to think through whether you want to remind that person what they knew at the time or not, because it might be useful for your case that they remember the things that they once knew, or it might not be useful. Your opponent might have figured out what they once knew and might be ready to remind them of those things, or might not have. These are all considerations you need to think through as you're preparing to prepare the witness, and then in the actual preparation of the witness to figure out what's going to make the most sense when you actually get to the deposition.
Another thing that often comes up, I think, during preparation sessions is a witness's request at times or request not at times to have a mock cross-examination during the preparation session. And I want to ask Frank about that. Frank, I'm sure there's a lot of different ways to answer this question, but I'll put it to you this way. Do you think there's value in cross-examining a witness during a preparation session, or is the defending lawyer better simply previewing information that may come up, or is it some combination? Can you shed some light for us on that question based on your experience?
Yeah, it's not an easy answer because it all depends on the witness. Obviously, I've defended expert depositions who have been cross-examined in front of juries more times than I've ever been in a courtroom in my life. That person is going to get no value out of me bringing in a colleague to do a mock cross on them. If anything, they're probably the smartest person in the room when it comes to any cross-examination. And then you may have a witness that is perfectly confident and comfortable, in which case also you're not going to get that much bang for your buck to spend time with a mock cross. And I think where you really want to consider it is when you have a witness that either clearly has a lot of self-doubt, is very uncomfortable, or is just generally scared of the process. And I think it's useful both to show them that this is what you can expect, so that they don't shut down when the inevitable starts to happen, and that they're prepared for it. But also to show them, you're in control. If you want a break, you just ask for a break, and then that can give them some of the confidence that they may have been lacking.
So we're at a point now where we're in the room with the witness that we're preparing to sit for a deposition, and the preparation has happened, and the witness is ready to go, and we're starting the deposition from the defense side. And I want to talk, using our remaining time, about that part of the scenario where the witness is in the deposition, and you're there side by side with the witness doing the defense. And one of the things that most depositions entail is objections on the defense side. I'm going to turn a question in Warren's direction on this. Warren, what's your view on the appropriate amount of objections during a deposition?
Well, I don't know if it's a question about the amount as to the appropriateness of the objections themselves. I oftentimes go full depositions where I don't object. There are other times where I am objecting a lot. And going back to one of the earlier questions you asked about jurisdiction, it does depend on that as well. In my jurisdictions, the only appropriate objection technically during a deposition is to form. And that means you're just objecting and you're placing that on the record so that later on, if it makes it to trial, you have preserved your objection and you can prevent your opponent from using that testimony in court, theoretically. You're not supposed to be making speaking objections. You're not supposed to be prompting witnesses. You're not supposed to be arguing about anything substantively. You're supposed to give the other side the opportunity to conduct their deposition. That is how it should be. And I try to stick to that. Not everybody does, obviously. Going back, Frank had discussed earlier what you do if people don't have the same principles in mind. But in terms of the amount, I would say if you're objecting a lot, it's probably a you problem. It's probably, unless you come across a notorious attorney who's just absolutely out of bounds. If you find yourself making objections after each question, I don't know that you're doing anybody any service, including the person that you're defending. Again, harkening back to what somebody said earlier, that you can annoy your own client and cause them to say things and get off track. So my general approach is let the other side conduct their deposition, object to form when necessary or when you think it's appropriate, and that's it. You'll deal with it, whatever comes out later on.
I wholeheartedly agree. And I would add that here too, it depends in large part on your witness. And when you have a good witness, the best thing you can do is let your good witness be a good witness. The witness can defend him or herself much better than you can. And if your opponent is asking bad questions and the witness can point out that they're bad questions or satisfy the obligation to answer the question in a way that is perhaps beneficial, let the witness do that and keep your mouth shut. Because at the end of the day, anybody looking at a transcript and seeing just a question being asked and a witness answering that question, that witness is going to get every benefit of every doubt.
Yeah, and conversely, sometimes, and I do this probably once a deposition, I'll ask bad questions. I'll ask a confusing question. And my opponent may object, and they're doing me a favor. And it's important to realize when that's happening and not be so antagonistic and confrontational that you're fighting on them. Sometimes there'll be an objection because you asked a bad question, and you should say, you know what, you're right, and ask a clear question so that you can use that later on.
Along those same lines, when I violate the prohibition on speaking objections, most commonly it's because I'm like, I didn't understand that question. I think what you asked was this. Was that what you asked, or were you asking something different? And I'll do that because I want to get the witness to answer the question that is being asked. I want a clear record. And when you do that, the next time you do object, you've got a whole lot more leeway in how you approach the objection. And suddenly you might be able to get in something that you otherwise probably couldn't have gotten in.
So we're approaching the end of our discussion here, and I wanted to try to get one more question, and I'm going to direct this one to Frank. This is about doing a redirect examination when you're defending a witness. And I wanted to see, Frank, if you have any thoughts on the usefulness of conducting a redirect of a witness you're defending at the end of their death.
Before Frank answers, I want to guess the beginning of his answer.
Please do.
It depends.
It does. It does. But I think that generally my general rule is I almost always never do a redirect unless I absolutely feel like I have to. And the reason that I really try to avoid it is because for me, as I always tell clients or witnesses when they're being deposed, this is, it's the standard spiel that most lawyers give, is that this is not your time to score points. This is your time to play defense and prevent the other side from scoring points. And when you when you do a redirect, you're opening the door up to more questions. Usually, as soon as they say, I have no further questions, I want to go off the record and get out of that room, and be happy with whatever I got. But there are times where something went so sideways, or the witness got something completely wrong, and they said something happened on such and such date that for a fact didn't happen because they were confused. And that's something that cleaning it up after the fact is really not going to be as helpful or effective. If it comes up in summary judgment and you try to submit a declaration saying, "Oh, I misunderstood the question, this was the true answer," you're in a much worse position. But in my experience, those are typically rare. And I think that a lot of lawyers, they just feel kind of like similar to how some lawyers think, if I'm not objecting, I'm not doing my job. So they object too often. Some lawyers also think, if I don't do a redirect, I've screwed something up because I'm supposed to do that. And I just take a different view, which is I almost never do them unless I feel it's absolutely necessary, because it's something I can't clean up after the fact.
And I think one point you raised, Frank, that really resonates with me is if you're in a deposition and that deposition just needs to end for various reasons, the last thing you want to do is prolong it. So I think, as with many of the topics we've been discussing, you just have to use your lawyerly judgment and discretion in deciding how much you want to pursue something, or how you want to go about something, or what your approach is going to be. And with that, I think we have sort of reached the end of our time together. And I want to thank you all very much for all of your insights on these questions. I'm sure we could talk for hours more about this topic. It's one that anyone who does any type of litigation comes across on a frequent basis, and you've all really offered some wonderful insights into how you approach these things. So thank you so much for your time and for your insights.
Thank you.
Thank you.